Hey, Facebook. This is David Jose coming and reporting to you live new, powerful information that you may have never seen before. And what we're going to do today is go back. And I'm going to open up the doors by God with the wisdom He gave me and show you exactly how these so-called juvenile and family courts are running game on us. I'm going to show you how they started this situation. I need you guys to share this thing like crazy. It is about to get crazy. I mean, super crazy. We're going to take some of the most high-level knowledge that you will ever see. We're going to put it together and break it down in simple terms so we can all understand and see what's happening to us. We're going to see how they're playing us for fools. Now, I'm going to tell you, a lot of us are trying to go to court or what we think is court and trying to stop these people from stealing our little ones. We don't understand what's happening. We can't figure it out. Nobody's telling us what's going on. Attorneys are taking us into the courts, taking our money. I keep calling them courts, but I shouldn't. Taking us into the administrative hearing buildings where the private Walmart business is and people are contracting you to steal your little ones. They're taking us in there, and it might not be all the fault of attorneys because the attorneys have been tricked into believing this falsehood for a long time. I'm going to show you where they got tricked at. I'm going to show you the years that it started. I'm going to show you how they did it. I'm going to show you them talking about how they were going to do it. It's going to break it down in their own words. See, that's the one thing about me. I don't want to tell you what's happening based on what I think and conspiracy theory and all this other stuff, myths, you know, all this crap. I just want to take their own documents and show it to you and let them tell you how great they are at stealing your kids and how they plan to do it, you know? So what we're going to do is we're going to go back and we're going to look at this gentleman, and I'm trying not to let the video go on with me talking about other stuff, okay? But what I want to do is welcome everybody on. Forgive me if I don't acknowledge you yet because I am adding people on. So I need y'all to share this like crazy. This video has to be given to all the people because it's going to get super ugly. Okay, we're wondering why these people are taking our kids, you know, all over the United States, giving them to sex offenders and all this stuff, and we can't get them, and the judges are saying we can't deal with it, the courts are saying we can't deal with it, that's not our jurisdiction and all this crap. But we're gonna find out what it really is, and then we're gonna show you how to break their so-called immunity that they have. We're going to show you how to break into their little trust and stop them from doing what they're doing. Now, Trump put out a law that talked about associations, organizations, and trusts that were used in order to traffic people. And y'all gonna have to forgive me for sweating. I am gonna sweat like crazy because it's humid and we got to get this video done. All right, what's up, Big John Gentry? You're gonna love this, my friend. You're gonna love this. All right, let's get ready. So we're gonna start from a book from the first chapter. It is called Administrative Law and Government, I believe, by Kenneth Cope Davis. You'll be able to see it in 1960. I'm gonna show you stuff from the freaking book. All right, so we're gonna just go read a little bit. Now I want y'all to see this. Look at this. Now it says, in 1929, Lord Hewart's book The New Despotism gave emphatic and emotional expression to concerns shared by most lawyers. See that? Both in England and in the United States. But the British Committee on Ministers' Powers investigated and reported no ground for public fear if the right precautions are taken. If the right precautions are taken. Now, remember that these people were training the lawyers who took over. And many lawyers were concerned because they're like, wait, this goes totally against everything that we have ever learned. Let's see what it says. James M. Beck, a former Solicitor General of the United States, published in 1932 a book entitled Our Wonderland of Bureaucracy. Uncle Sam has not yet awakened from his dream of government by bureaucracy, but ever wanders further afield in crazy experiments in state socialism. Watch this. Possibly someday he may awaken from his irrational dreams and return again to the old conceptions of government as widely defined in the Constitution of the United States. Beck's book was poor scholarship, but it may have been effective politics. The auto bureaucracy slogan became popular with all parties. Now it gets into talking about the New Deal. Now watch this. Opponents of the administrative process usually paid little heed to the view that the agencies were administering constructive programs. I keep telling y'all that they're administering programs. They're not moving as a court of law, but they're just dealing with programs and administering programs. Watch this. The agency, especially the SEC and the NLRB, were for most lawyers becoming the symbol of obnoxious political philosophy, which was fast destroying freedom. We're wondering why our freedom is being destroyed. We're wondering why they're not looking at the Constitution. And this is going to tell you why. And nobody's showing us this. Watch this. The American Bar Association went into action in 1933. It appointed a special committee on administrative law. Why would you have to do that? Why would you have to do that? Which in 1934 began a series of annual reports. The judicial branch of the federal government is being rapidly and seriously undermined. They are telling that the judicial branch was being taken over by administrative law, which is exactly who is taking over our children now. Now we're gonna show you some power. Watch this. The committee naturally concludes that so far as possible, the decision of controversies of a judicial character must be brought back into the judicial system. Look at this. This is in the 1930s. They were already saying that the decision of controversies of a judicial character must be brought back into the judicial system. So what is that saying? That's saying that the administrative law actors who wanted to take over the United States and remove our freedoms started to remove everything from judicial courts to administrative courts without the people knowing. Without the people knowing. You see this? Watch this. In 1938, the committee, this time headed by Dean Roscoe Pound, reported 10 tendencies of administrative agencies to decide without a hearing, to hear only one side. Does that sound like your CPS cases? To hear only one side, to decide on evidence not produced. Are you freaking kidding me? In the 1930s, they were letting you know that administrative agencies will not produce evidence to take something from the people or to make a decision. And this was happening way back then. And it's happening to us now. To make the decisions on the basis of performed opinions and prejudices. So we have the same thing. We see CPS making decisions to take our kids based on ideology and things that have no position in common law, but they're using this stuff against us to take our little ones. Now, watch what happened in 1939. President Roosevelt, we're starting here, hopefully you can see. President Roosevelt, on February 16, 1939, requested the Attorney General to appoint a committee to investigate the need for procedural reform in the field of administrative law. A committee of distinguished practitioners, judges, and professors was appointed, which set about in task in scholarly fashion. It went after the facts. Its staff interviewed administrative officers, subordinates in the agencies, and practitioners who had cases before the agencies. Where were these cases at? Were they before judges? No. Cases before the agencies. When you look in your states, you're going to find out your cases are going to be before the agencies. They're going to be making administrative rulings, but they're hiding the language to make you believe you're in a real court. Watch this. A detailed monograph was written on each agency, submitted in tentative form to the agency, and the committee and the agency then discussed the problems raised. Therefore, the committee held public hearings to receive opinions concerning the descriptions of procedures and the criticisms in the monographs. An elaborate report was finally prepared, which, when its appendices filled 475 printed pages. This report, together with the monographs on which it was based, is still the primary source of information about the federal administrative process. Even though it's out of date, no new comprehensive study has penetrated so far. So let's look down here. Its proponents seem fully aware of its devastating character, for they exempted from its provisions the agency whose work they were anxious to protect. The bill was passed by both houses, but the president veto was upheld. We're going to jump down some more. The administration and the American Bar Association forces finally compromised, and the result was the enactment in 1946 by let me get this next page, forgive me, by a unanimous vote in both houses of the Administrative Procedures Act. We all need to look at this, of 1946. This is what Michi Slay schooled me on, that has been a blessing, because the Arizona DCS and everybody else's CPS is working outside of the Administrative Procedures Act. Now let's see what we found out about when they did this. And I'm sorry for talking so fast, guys, but watch this. That's right, Brandy. They don't move up under the common law. We're going to prove it today. We're going to show these clowns are working outside of the law, and we won't have this argument no more. Watch this. The major effects of the act were to satisfy the political will for reform, to improve and strengthen the administrative process, and to preserve the basic limits upon judicial review of administrative action. Your CPS in every state is doing an administrative action, and they're forcing it on you like it's judicial. The American Bar Association have fought for the propositions that the decision of controversies must be brought back into the judicial system. That's telling y'all that they're not using the judicial system. That's why we're getting into trouble now, because in the 1930s they did it, and now it's time for us to turn around and come back to what is right. We can no longer be stuck into stuff that is false and end up tricked. And I'm going to show y'all something that's going to make your heart drop out your chest, because it's that deep. Watch this. Let's see. So it said they have to be brought back into the judicial system. And then it says that life tenure should be assured to all who are to exercise judicial functions. That administrative absolutism, which is what's happening, stems from freaking Marxism. All right, we know Marx was controlled by the Jesuits and believed in socialism. So administrative absolutism stems from Marxism, and that the administrative process should be crippled through the Walter Logan measure, but the association was apparently reasonably satisfied with the APA. So if they followed the Administrative Procedures Act, it'd be a lot better, but they're not following the Administrative Procedures Act. And so what ends up happening is that the agency is going under administrative absolutism, which comes up under Marxism or socialism. Okay, socialism is what's being used when they use an administrative process that's absolute and giving an agency whatever they want. And we just seen here that the information is going before judges without any evidence. Okay, the judges in the room are not looking at any evidence that's legitimate or real, and just following the agency, which we find out in administrative law makes all the orders null and void. Now, I don't give legal advice, but what I'm doing is just showing y'all what people are saying for entertainment purposes, information purposes, and so we can just review what is said. Now, watch this. Even though it transferred no power back to the courts, so the APA didn't transfer power back to the courts, did not substantially increase judicial review. Still, nobody was making sure that we would have judicial review of our cases. That's why when I called Arizona, asked them about a judicial review, they act like they didn't know what it was. Continued the system of adjudication by those enjoying no life tenure. Now, what is this talking about? See, they're talking about the fact that they're not judges in the process of doing these transactions. So they're coming in, and an agency is allowing somebody who has no life tenure to come in for a little while, act like they're a judge, make a decision in your life, run away and go back to their normal job as a judge, and they make you think that they are they're judges, and they're not. That's why they don't have life tenures. None of your freaking juvenile court judges are there for life. In Arizona, they come in, they get rotated, and they leave out. They're making decisions by what the agency says, based on the report of the agency, like I just showed you, which shows that it's an administrative process and not a real court. And we were suffering through this in the 1930s. Watch this. And in general gave assurance that further efforts to cripple the power of the agencies would be unlikely to succeed. The battle over fundamentals had ceased. The federal administrative process seemed secure. Watch this. After the enactment of the APA, a period of relative tranquility set in. Judicial interpretations of the APA were generally sympathetic to its purposes, and the act's middle position seemed to satisfy the formal partisans on both sides. The courts kept on grinding out refinements of the administrative law, both under the act and apart from it. Okay? We're going to go down a little bit more. Watch this. In 1955 came the report of the President's Conference on Administrative Procedure, which had been appointed in 1953 to inquire into the narrow subject of unnecessary delay, expense, and volume of records in some adjudicatory and rule-making proceedings. The report was mild and helpful, and except, for the troublesome problem of status and hearing officers, mostly non-controversial. Okay, so we're going to look at a little bit more, then we're going to get in some fire. Okay, let's see. Watch this. Attorney General Herbert Brownell said that the task force recommendations to amend the APA, that's the Administrative Procedures Act, watch this, the changes would substantially judicialize the administrative process. So they're trying to make the administrative process judicial, with disastrous results to efficient and effective government. See, you can't have efficient government when you're using administrative business and private companies to make decisions in people's lives, because there's no longer a situation where the government is making decisions. You have agencies making decisions. Watch this. The proposals are unsound, unworkable, and so costly that they should be rejected. To summarize, it seems plain to me from my study of this group of commission and task force proposals that far from achieving the commission's objectives of attaining economy, see, they want to get economy, they want business to go real fast and fly, efficiency and improved service in the transaction of public business. These proposals would do exactly the contrary. So what they're doing is they're trying to make things go fast. They're trying to get things to just run through, and they're not necessarily trying to use the law and work in a way that a court of law would work. Watch this. 1A. A prohibition of off-the-record consultation of deciding officers with technical advisors or assistants. What? A prohibition of off-the-record consultation of deciding officers with technical advisors or assistants. Now, we're going to see this later. We're going to find out this is what CPS is doing with their little private membership association. And we're going to break it down. A provision that an agency member, notice it's talking about the members, or hearing commissioner who presides at the taking of evidence shall be disqualified to participate in agency review of initial decision. A requirement for most adjudication that rules of evidence shall conform to the extent practicable with those in civil non-jury cases in the United States District Courts. A provision making a presiding officer's findings of fact final unless the agency deems, not a judge, the agency deems them clearly erroneous on the whole record. Judicial review of every final agency action for which there is no other adequate remedy in any court. That's why we can't find any remedy in any court. We're not dealing with a judicial court, people. We're dealing with an administration. A slight broadening of the scope of judicial review of administrative findings of fact. Now, this is outrageous because we're having these same things happen to us. Watch this. People think that we're in common law. No, we're not. Watch this. By 1933, the old common law method of letting defrauded buyer of security sue the seller had proved itself thoroughly unsatisfactory. Alternative methods were studied, and the result was the invention of methods of prevention. And okay, so now we see that we have this so-called, excuse me for my sweat, we have this so-called prevention in CPS where they say, oh, well, we're trying to prevent abuse. And the thing is that they're not trying to prevent abuse. What they're trying to do is find a way to make public business really fast. But what they do is when they get into this administrative stuff, they leave from public business and they start going into private business because the case is being handled by a private agency that's a private business. See, what they should be doing is they should be taking us into a court. Now, some people will say, well, no, they shouldn't be taking us into a court. It's okay to do administrative hearings. No, you should be taking us into the court. Watch this. I'm going to show you another booklet. This right here is called, it's a scholarly journal article, University of South Carolina, Scholar Commons. Filling the due process donut hole, abuse and neglect cases between disposition and permanency by John Gupta Kagan. Now, I'm not bringing you some garbage. What I'm doing is I'm bringing you scholarly journal articles. That's what I do. I love researching, and forgive my sweat, but this is important. I had to do this video and get it out to you guys. Now, we're going to see that there is no complete due process and no way to give us due process. Now, based on what I just read to you guys, I'm going to show you what these people are telling you that lawyers and regular people are going to see. Now, people want to tell us that we are in civil cases when we deal with the courts when it comes to CPS. No, we're not in civil freaking cases. Watch this. Watch this. Due process protections in abuse and neglect cases, the beginning and ends of cases. Watch this. Lawyers unfamiliar with abuse and neglect law would feel comfortable walking into trials held at the beginning and ends of abuse or neglect cases. Now, we're going to see something they're doing wrong to us. Watch this. They would see bench trials. Watch this. Bench trials that have due process hallmarks of most civil litigation. Now, watch this. This is where it's going to get ugly. A case typically begins with the government. What? What does this say? Formally charging. Formally charging. How do you formally charge? You make criminal charges against a parent, right? Watch this. The government formally charging a parent with abusing or neglecting his or her child and asking a judge to put the child into government custody so it can protect the child from further abuse and neglect. So after you charge them, now you have to ask a judge, not an administrative hearing officer, but a real judge to put them inside of government care. You can't just snatch the kid from the parent or say, hey, I'm going to ask the judge to remove the kid from the home because we want to and we have concerns. It says they have to formally charge. Now, why is this important? Because people are lying to us and saying that the state can write a permission slip that says that CPS can go in your house and take your kid. But remember, I told you guys that it had to be a court of competent jurisdiction that made the decision. And to formally charge, it has to be a criminal court. Watch this. Here's the 18 U.S. Code 3127, and it's going to be the definition of a court of competent jurisdiction. What does it mean? In the state, it says a court of general criminal jurisdiction of a state authorized by the law of that state to enter orders authorizing the use of a pen register or a trap and trace device. Can the freaking CPS court do that? No, they cannot. So what happens is that means that they are sneaking and tricking us into believing that we are in a court when we're not. It's the agency giving orders and they don't have the ability to. Watch this. Contrary to the welfare determination under section 472(8)(2) of the Act, a child's removal from home must have been the result of a what? Judicial determination, unless child was moved pursuant to a voluntary placement agreement. That means you agreed to it. Now, how do we know for sure? Watch how these liars work. Court orders that reference state or tribal law to substantiate judicial determinations are not acceptable. So when they tell you the statute says that we can take your kid, freaking lie. Stop it. Even if the law provides that a removal must be based on a judicial determination that remaining in the home would be contrary to the child's welfare, or that removal can only be ordered after reasonable efforts have been made, you can't use that in these state courts to take somebody's kid. So when they show you this fake law in the statute saying, hey, our statutes, our permission slip written by the legislator who's selling business for us and hooking us up so we can make some private money and we can give them kickbacks, they say in their law, look at what the actual act says. The actual real act, the Title 4E plan, says court orders that reference state or tribal law to substantiate judicial determinations are not acceptable. You can't put in your statute and say, therefore, we can take the kid because the statute says so. There must be a judicial determination. What does judicial determination mean? Watch this. Well, you can't do it if you got a contract with the states. We're going to look at the parties involved. Title 42, 674, cooperative agreements. They got people involved by contract, which is different from a judicial determination. This is a private business getting together, lying to take your kid. Watch. This is talking about who they're going to give money to in the cooperative agreements. Short-term training of current, prospective foster or adoptive parents or relative guardians, the members of staff of state licensed or state-approved child care institutions or state licensed or state-approved child welfare agencies, providing services. They're businesses that provide services. This ain't no judicial court. To children receiving assistance under this part and members of the staff of abuse and neglect courts. Wait, y'all got contracts with the abuse and neglect court? Well, that's not a judicial court, because you can't pay the judicial court to work on your behalf and partner with you and still be judicial. Agencies, attorneys. Yes, the district, not the district attorney, but the attorney general's office. They're under contract too. That's why when you go to Attorney General and you try to tell on CPS, they can't do anything because they work for CPS. They're under the same darn contract. Watch this. Attorneys representing children or parents. So the dang attorney they give you is under contract with Title 4E. The one they give to your child, under Title 4E. Guardian ad litem, they're under Title 4E. Everybody's working business together. Or other court-appointed special advocates representing children in such proceeding of such courts. Okay? So they're all dealing with private contracts, guys. That's all they're doing. But they're getting us because they get us to believe that it's a judicial termination. Watch this. 45 CFR 1356.21. Payments, programs, implementation requirements. Now, what we're going to see is these people are running game. They're running game. Watch this. In order to take the child, in order to start this process up, judicial determination must be made. That means a court tried you by a jury of your freaking peers and said you did something wrong. If not, and they have not charged you, these people are fraudulently tricking you to come into their so-called courts to do business. Watch this. If the determination of reasonable efforts to prevent removal is not made as specified in paragraph B1 of this section, the child is not eligible under Title 4E for maintenance payment program of that state in foster care. Judicial determination of reasonable efforts. There must be a judicial determination. Remember I showed you guys where they said that the administrative law characters will try to take away the judicial determinations or the power of the judiciary. The Title 4E agency must obtain a judicial determination, okay? But these agencies are not providing judicial determinations. They have to charge you and convict you to prove that you are not capable of taking care of your little ones, and they're not doing that. Family are not required if the Title 4 agency obtains a judicial determination. Watch this. A court of competent jurisdiction has determined the parent has subjected the child to aggravated circumstances. Now, we know in the federal law what that means. Watch this. Let's see what it means. Murder. Okay? If the offense had occurred in special maritime or territorial jurisdiction of the United States of another child of the parent, you had to kill one of the kids. Voluntary manslaughter, you had to get charged or convicted with this. Aiding or abetting, attempting, conspiring, soliciting to commit murder or such a voluntary manslaughter. This is what they're supposed to use. And this wasn't for people to just come take your kids from you because they had concerns that your dishes weren't clean. This was if somebody killed somebody, got convicted, you killed your spouse, got convicted, so the kid had to go into care because a judge in a judicial court said you were guilty. Watch this. A felony assault that results in serious bodily injury to the child or another of the parent. So that means that you had to get in trouble for committing some crime, hurting somebody, killing somebody, get prosecuted before you freaking before they freaking remove a child from your darn home. So these people have tricked us to believe that the CPS court can just write a permission slip saying, hey, we're going to just go ahead and remove your kids from you because we're God and therefore everything is going to be okay. Now let's look at the due process protections, because this is about an abuse and neglect course. Notice this. A case typically begins with the government formally charging a parent with abusing or neglecting his or her child, asking a judge to put the child in the government's custody. If they ain't trying to take you to court and prosecute you, they're full of bull crap. If they don't convict you and show that you did something wrong, they're full of bull crap, but they're threatening us these days, getting us to drop our kids off with them, talking about we're going to get arrested if we don't, and they're just private businesses, which goes against the Federal Debt Collections Practices Act. You cannot do that. Now watch this. In constitutional terms, the government must prove. How do you prove? Not by taking them to a CPS court. Excuse me for the sweat. Not by taking them to the CPS court and saying, we're going to say that you did something wrong, and therefore the agency is saying that we need to take your kid and keep your kid, and we need you to work with us and do services so we can make some money with our partners. So we're trying to find out if you did wrong or not. No, the freak, you're not. You're trying to find out how quickly you can rehome the kids, and after you rehome people's kids, you want to adopt. Shut the freak up. You're liars, okay? So what's happening is they have to prove you did something wrong. Watch this. In constitutional terms, the government must prove that the parent is unfit to justify changing custody. They can't just take your kid out your house with no warrant, with no court orders from an actual court of criminal jurisdiction that can throw your butt in jail. Watch this. The government, like any other party seeking to prove a case that it files, puts on witnesses and introduces evidence. They don't do that in that fake court. And this is why they're trying to trick us to believe we're in court with a judge in the front. Because their administrative hearing is acting like it's a legal process when it's not. Opposing parties cross-examines the government witnesses, challenges this evidence, and can put on their own case. That don't happen in our courtrooms with these fake courts. The judge considers the evidence presented, his or her state's substantive law, and relevant constitutional law. They don't let you use constitutional law in these Title 4E courts. They don't have jurisdiction to hear it. I keep telling y'all. Now I'm showing y'all. And then enters a ruling which parties may appeal. Okay? May appeal. Watch this. The judge considers the evidence. A ruling that parents have abused or neglected their children justifies a temporary remedy, typically placing a child in foster care. But when is somebody proving their case with the court of competent jurisdiction that could throw your butt in prison? Never. Their case, watch this. Parties seeking to terminate a parent's rights must prove their case by clear and convincing evidence. Guys, we are freaking being played. I showed y'all where, not me, but government committees, the bar, told in the 30s that this is what they were doing. Okay? Told what they were doing. People didn't want to hear me, but I'm showing you now what they're doing with their own documents. Their own documents. Now here's the thing, guys. I showed y'all before that common law is held outside. A court of record does not use the statutes, but they're having permanency hearings about our little ones. And watch this. These permanency hearings are creatures of statute. How the heck are you giving us a trial by jury or a court of record trial, if you're using statutes? The judge is not making a decision if something is right or wrong in the law or the facts. The judge is being forced and bound by statutes. When the judge is bound by statutes based on K.C. Davis's book, Administrative Law and Government, you find that these people are working ministerially as clerks for the involved agency. So if the agency creates if the statutes creates the agency CPS, and then CPS goes into a courtroom where a judge is bound by only statutes, the judge ain't making judgments in his judicial capacity. He's working with the contract that's created to make that agency and the funds that are coming in from the federal program. Therefore, he can't do anything but what the federal funding program says. Y'all don't believe me? Let's see. Federal law requires, as a condition of federal funding. You don't have to take the federal funding, but if you're going to take the federal funding, the condition is, federal law requires, as a condition of federal funding, that all states to comply with certain minimal procedures in abuse and neglect cases. They have to do everything that the federal government tells them to in order to get the money. So they ain't making judgments. They're just making rulings based on the process that's put in place by the federal corporation that is governing their business. So the federal corporation is giving money to them to make decisions. Let's look. We'll prove it. 675-5C1 2006. The first permanency hearing must occur within 12 months of the child's entry into foster care. See, that's the terms that are put in place in the codes and 45 CFR and Title 42. That's what's put in place by them. A judge is acting on statute alone. Now, I'm going to show y'all who the heck is doing this to us, okay? Because people want to make it look like they're giving us a fair shot. But it's a trick. Watch this. Watch this. Thinking back to my time as a trial judge, I remember a social worker, somebody coming in and arguing the individual who had been adjudicated neglectful or stipulated to neglect had once again failed to do something that they had been ordered to do by the court, and therefore they were recommending that the goal should be changed. I was never sure if there was a requirement or a notice that was given that at this hearing we were going to be discussing a change. So the judges are being told at the last minute what's going on in these so-called courts, and is based off of ASFA. It's not based off of them finding you as had done anything wrong and trying to make a decision that's fair. They're listening to the agency who comes in with the report, usually a little bit before they have to have the hearing, and then that's how they make their decisions. Now, let's talk about who is actually dealing with our court cases. Everybody want to say the state of Arizona is handling our court cases. No, the state of Arizona is not handling our court cases. No, the state of whatever you in are not handling your court cases. Who's handling your court cases? Private membership associations, private trusts, private businesses. I'm going to prove it to you. Don't take my word for it, please. Let's look. The National Council of Juvenile and Family Court Judges. What is that? The National Council of Juvenile and Family Court Judges, a what? Membership organization of courts handling abuse, neglect, juvenile delinquency, and other cases. Wait, did this say the National Council of Juvenile and Family Court Judges, a membership organization of courts? Or did it say the state of Arizona Superior Court, the state of Kansas Superior Court, the judges of the state of Nebraska? No, it did not freaking say a state, okay? It did not say a state at all. What it clearly said was the National Council of Juvenile Family Court Judges, a membership organization of courts, okay? They're not courts. They're a group of people who come together as a membership organization who has members, okay? They have members. And these members are people who are coming together and making decisions for your family and for your kids in an administrative hearing that they make look like it's a court. How do you know they're making it look like it's a court, David? Watch this. They provide technical assistance to judges nationwide, has issued guidance for permanency hearings. How the heck do they guide judges if they're acting in their judicial capacity? They wouldn't be. That echoes the law in the District of Columbia. The council urges judges. What the freak do you mean urges judges? Watch this. Urges judges to make written findings of fact and conclusion of law. Well, dang, a real judge would already have findings of facts and conclusion of law. Why the heck you got to get these members to write, the judges who are members of these organizations, private membership organizations at that, which they traffic us into, and I'll explain that in a little while, including whether the state agency, see, the state agency is created by statute or a private business, so they're not a state agency. They are not the freak state. Stop believing this garbage that the state is coming after you. There is no state coming after you when your court case says in the matter of your kids in the county of some capital letter name all the way across it. And then all you see is that you have private parties coming in there, judges not using their real name that they normally use on a roll of attorneys, attorneys not using their normal name on a roll of attorneys. They're doing this because they're doing private business. They're jacking you of your kids. They are raping you, just like the Administrative Procedures Act said, and just like the people said in history, the attorneys and the president. Watch this. Whether the state agency has made reasonable efforts to help the family reunify. Now, if it's a private business and it's a private membership association and they're all part of it, hold on, let me wipe my lens off, sorry. If they're all a part of it, why is the one who's coming against you as an adversary also the one who's providing you services? Don't businesses provide services? Yes, all they're doing is providing services to you at the barrel of a gun. They steal your kid first, then they provide you services. But they never took you to court. Watch this. The council has admonished members. What? The National Council of Juvenile and Family Court Judges. The council has admonished members that permanency hearing findings should be more specific, final, and definitive than a review hearing. They're telling them how to perform, guys. They're telling them how to perform. But the council's description of permanency hearings lack any reference to examination of witnesses. They're not even saying that you have to examine witnesses, documentary evidence. Y'all wondering why you can't get evidence into the courts. This is why they don't give a freak about documentary evidence or other trial type procedures. There's no mention to trial type procedures, not trials, trial type procedures, because this association can't give you a trial. It cannot give you a trial. It gives you trial type procedures. Now, this goes back to the Administrative Procedures Act, because the Administrative Procedures Act tells you that they're not giving real trials. They're giving trial-like hearings. It looks like a trial, smells like a trial, but it ain't a real trial. Now, we got to go deeper, y'all. We got to go deeper. Watch this. The council also does not specify what detailed factual finding would justify a particular permanency plan ruling. They're just trying to find permanency. You think they're trying to put you in jail? No, they're just trying to find permanency. How to get your kid out your freaking house and into somebody else's house where it's permanent so they can adopt and make money. That's what the business is about. Instead, the council writes that state agencies should propose their recommended permanency plans to all parties in hearings, and the other party should submit a report if they disagree with the state's proposal. It ain't the state, it's the private company. Watch this. Such reports should set out facts to support the party's position. The council guidance includes no discussion as how courts are to determine whether a party's view of the facts is accurate. They're not trying to see if you're right or not. They're not trying to see if CPS is correct or you're correct. They don't give a darn about evidence because it's not a real freaking court. And you're in there talking about my case. The evidence says that I was right. No, the evidence says you were right. No, the evidence says nobody's using evidence. Let's stop talking about all this evidence and let's deal with the fact that they're stealing our kids and in a legitimate court. Period. Okay? Period. They're not looking at you about evidence. They just want you to think that's happening, because if they do, they can keep you caught up in everything that's going on. You'll never realize they're just rehoming your kids for a business. Now, nor does the council suggest how to respond to delayed or incomplete agency reports. See, your agency don't turn in your CPS reports, don't turn in the fact that you did all your services, don't turn in all that, because they don't give a darn, and nobody's doing anything to them if they don't. So we're arguing over the wrong things. Everybody's arguing over who's the smartest. Everybody's arguing over who's the best at doing their documents, and who's this and who's that, and who can write the best briefs. Screw the briefs. You ain't in court. We're not in court. We're in the midst of a private membership association that is tricking us to believing that it's court. Now watch this. The council guidance also includes no suggestion that permanency hearing rulings are subject to appeal. If they put your kid somewhere and say this is for permanency, you can't even appeal that. Its guidance speaks of appeals from adoptions and terminations of parental rights. They say you can appeal adoptions and termination of parental rights, but not appeals of permanency hearing decisions. In addition, the federally required, this is a federal program, this ain't no court, guys. Permanency hearings, many states require review of disposition hearings, and these review hearings often overlap permanency hearings. So guys, people keep trying to tell us we're in a court, all right? They keep telling us, but we're not freaking in a court. We're not. Watch this. Although significant state-by-state variations exist, the law of the District of Columbia and the recommendations summarized by the National Council of Juvenile Family Court Judges are illustrative. Now, we're going to jump to, I think it's page 28 or 30. And I'm sorry, guys, I'm going so fast, but this is some real stuff that we need to realize is happening. Now, this is in their own scholarly journal articles explaining what's happening in these fake courts. Watch this. The standards or lack thereof summarized above govern all decisions made at permanency hearings. So there's a lack of standards for permanency hearings, and they're admitting it, including both permanency plan decisions and decisions whether administrative agencies have made reasonable efforts to achieve a child's existing permanency plan. It is not surprising, therefore, that state courts implementation of federal reasonable efforts. So the state courts handling federal issues, okay? It's not a state issue, it's a federal issue. The state is just following suit because that's how they get the money. Reasonable efforts requirement has faced criticism. Why? Same thing y'all been telling me. As substance-free rubber stamp decisions by state judges. The judges are making decisions based on some bullcrap. A significant, and they're letting people rubber stamping whatever these agencies want. A significant problem given the importance of reasonable efforts in the federal statutory scheme. They're going by federal statute, not the state. And the unavailability, see, we ain't got no remedies, y'all. Watch. And the unavailability of remedies to enforce states' reasonable efforts obligations. There's nobody you could go to in the federal government to tell. Why? Yes, ma'am, I'll get you one. There's nobody to go to because it's a federal corporation, it's a private business, and nobody can hold them accountable. In the absence of a federal definition of the term or adequate federal funding for the prevention or reunification of services, judicial findings of reasonable efforts are often made by judges by rote. That means they're just mechanically doing it. But they can't make an order because they are also parties who are making money off of Title 42 Title 4E program funds. Their orders are null and void. When such decisions cannot be appealed until the end of a case, watch what they do, y'all. When an adoption decree or termination of parental rights decision is entered, appellate judges face strong incentives to avoid close examination of reasonable efforts decisions. Y'all want to know why I didn't do an appeal? Because the appeals court is really not doing their part, because they're looking to see if the administrative agency went by their own process when they're going to cook the record to say whatever they wanted to say. Early in the case, let's see, overturning a permanency decision based on lack of reasonable effort early in the case could upset stability for a child who has been previously neglected or abused. But the problem is, y'all ain't proven that people have neglected their kids. Okay? Y'all not doing that. Watch this. A full exploration of the right to counsel throughout a dependency case is beyond the scope of this article, except to note the correlation between the right to counsel and the right to put on and challenge evidence, and thus between states that have disregarded informed opinion, which has clearly come to hold that an indigent parent is entitled to the assistance of appointed counsel. Watch this. In dependency and neglect proceedings, and those that do not see the value in basing permanency hearing decisions on evidence. They're not looking at the evidence. We're trying to prove stuff with evidence like, hey, I'm not guilty. I'm not wrong. I didn't do anything wrong. Y'all know I didn't do anything wrong. But they ain't looking for that. They're not looking for that. You in the wrong court arguing the wrong thing because this ain't even what it's about. Now, I'm going to show you a little bit more and I'm going to let y'all roll. Among states that do not permit parties to appeal permanency hearing orders, the most frequent analysis in such decisions are not that such decisions are not final orders. Thus, appellate courts lack jurisdiction over appeals of these orders. The policy concern animating this approach is taking the time to appeal such plans makes little sense when trial courts face strict federal timelines. They're only working based off the federal statutes. That's why they're doing all the stuff they do as a condition, as I showed you earlier, for getting money, for moving toward permanency. An Arizona appellate court worried that permitting such appeals would undermine the primary purpose of ASFA, the Adoption of Safe Families Act, the federal funding incentives, and conforming Arizona law, expediting the process of finding permanent placement for children. That court did not discuss the reality that we have already seen, that even with ASFA timelines, a significant number of children remain in foster care for an extended period of time. States like Arizona that have held that permanency plan orders are not appealable include these. I'll just let y'all see that. Just so you can see it for your state. But guys, this is a big issue. We are being tricked. We are being deceived, and we don't have any remedies because this is a purposeful thing that was done a long time ago to stop us from being able to make a case to have our little ones. This is all it is. This is all it is. They're a private membership organization acting like they're in court, and they're not. And they trick us to think we're in court. They talk to you a little bit about stuff like you did stuff wrong. We believe you did this. We believe you did that. They don't care if you did this or not. Their whole job is to take your kids out the house, get them in another house so that they can hurry up and get ASFA money. Now, I'm going to show y'all about the private interest that's got to 15%. Please stop messaging me, whoever's in that big group. They're messaging into my private messenger and it's going to kill my battery. Okay, watch this. Due process arguments for more meaningful procedural safeguards. Watch this. I'm going to have to skip down. Hopefully y'all can go back and play it. In certain situations, children and parents' constitutional due process rights demand some minimally sufficient procedure safeguards at permanency hearings. At the very least, the decisions be based on evidence. Parties have the ability to present evidence and call witnesses, and witnesses be subject to a cross-examination. In addition to these trial court rights, the right to appeal adverse decisions will be discussed in part 3. Look at this. Considering the importance of the private interest at stake, the risk of erroneous decision under the procedures currently used, and the probable benefit of alternative procedures and the government interest, government interest, even though they're private businesses, to discuss what circumstances permanency hearings should trigger these procedural protections on a constitutional basis. But they ain't using constitutional basis. Private interest. The importance of constitutional rights to family integrity is well settled. We're going to look at Troxel versus Granville. In 2000, when it was most recently addressed, the constitutional rights of parents in detail, the Supreme Court wrote that the liberty interest at issue in this case, the interest of parents in the care, custody, and control of their children, is perhaps the oldest of the fundamental liberty interests recognized by that court. Y'all want to know why I use the habeas corpus? Because it's a freaking fundamental liberty interest that is not supposed to be touched by government officials or private businesses trying to come in without proving you did something wrong and stealing your little ones. They never proved I did a crime, and they most likely never proved you did a crime. But they're tricking us to acting like they did, while using a court that's paid for by them to get a judge to write an order that's not an order, because they're making money in the case. You can't do it. For nearly a century, parental rights have formed core elements of the Supreme Court's substantive due process jurisprudence and have been repeatedly reaffirmed, being described as the matter of intrinsic human rights. Reviewing these cases, the court concluded, in light of extensive precedent, it cannot be doubted that the due process clause of the 14th Amendment protects the fundamental, due process of the 14th Amendment protects the fundamental rights or right of parents to make decisions concerning the care, custody, and control of their children. Although they are less established than parents' rights, the custody of their children, some courts have recognized the reciprocal right of the children to live with their parents. So here, Sandra Day O'Connor so beautifully speaking showed that parents have a right to control their children's upbringing, and children have a right to be with their parents. And this is being broken by these courts who come in and just remove your children with no proof of anything being done wrong just because an agency says so. Okay, so we keep seeing this foolishness. We keep seeing all of this trial type procedures and all this stuff. And I just want to let you guys know, I hope that you can see, and excuse my sweat, I'm sorry. I hope that you can see that these people are running game on us. I'm hoping that you can see that the Administrative Procedures Act tells us that they were going to be doing things that would destroy the judiciary. I hope you can see that the Administrative Procedures Act told us that they can't just come in and do whatever they want to do as an agency without evidence and remove your little ones. It goes against the Constitution. Now, this is why they don't bring us into a court of record, because a court of record will demand that you bring in evidence, independent evidence, not from an agency that just gets to write a report and say whatever they want to, and there's no punishment if they lie. This is why the Vreeken case, the Hardwick case, when it came out and it said that any caseworker should know that you can't just lie on a parent to remove their children. When we see that, you cannot use those methods. But this is what's happening in these private membership associations, because you're allowed to lie in there because it's a private business. It has nothing to do with you going in front of a jury of your peers or a court of competent jurisdiction, guys, okay? So I hope this video has been beneficial to you. We see that it's the National Council of Juvenile and Family Court Judges that are handling most of these cases. It is not a court of record. It is not the Superior Court of Arizona. It's another branch that is working under the court that is contracted to provide services, and the National Council of Juvenile and Family Court Judges are teaching people across the country how to steal our kids from us, how to rip them off, how to run a private business. They're using the private membership organization in which they get paid money. They get paid big money to take your little ones through Title 4E. They're running scams. Now I'm gonna tell y'all how to break a membership association, because I own membership associations. A membership association allows you to work in the private, where you can do things and the state or the federal government has no jurisdiction over what you're doing. When people make raw milk and they sell the raw milk bottles and give you the milk for free, that's how you no longer see feds coming in with guns taking over their practice, or you see or business. You see chiropractors using private membership organizations now, and everybody in the membership organization can allow for the services to be provided, and it's all outside of government jurisdiction. And there's only one way to get by it. To get by it, you have to show nefarious acts happening inside of the trust or the membership association or the organization. Once you can show nefarious acts, it can be penetrated. So what's happening is that there's private courts and private businesses. Call Arizona today and ask if they work with the National Council of Juvenile and Family Court Judges. Call the National Council of Juvenile and Family Court Judges and see their 30,000 members across the United States, guarding that line, judges, different parties, all taking part with them to discuss outcomes and bring forth more money in business. Guys, we are being had. It's a hoax. We need to pull them into courts of record. Every individual party who does something wrong, send them affidavits. Let it be known what they did wrong to you. My phone is going to die, so I'm going to try to hurry and get off. But let them know what they've done wrong to you. We can talk about how to do that for days. John Gentry said he want to get with me, work on stuff. Let's get together as a nation and blow the back out of their little freaking private business. They think that we're stupid. They think that we won't track down everything they're doing, find every little bit of money that's hidden. We will find every little thing. You're not going to get away. You're not going to get away. We're going to see you have this. The video is gone, guys.